for the court to compel the state to provide them with further particulars. You may have heard that our response to them was based on the fact that their request or the particulars that they requested had nothing to do with the case in hand, and it did not form part of the evidence that we presented or we intend to present in court. Therefore, it's upon them to make that application with the person or the company wherein they need or require information from, which in this case is the car dealership where the accused was employed previously.
Well, Henry, we also know there is, of course, that matter of the recusal of the previous presiding officer in this matter, Mr. Mphahlele. Where are we in regards to that application?
Well, you'd recall that that as well was a bone of contention in court today, as the accused felt that the state did not file for a review application, and we've proven to them that a review application was filed with, a notice was filed with the High Court, and there was correspondence between the state and the registrar of the High Court. We even provided this court today with the case number to prove that that matter has been registered with the High Court. Now we await, as the magistrate rightfully said, we cannot continue with the bail amendment hearing before the judgment on that review. So that's where we are with that matter. That matter will have to await the outcome of the review application.
There was also quite a lot of anger coming from those on the defense side, saying that there is a very clear indication by the state that they are stalling and dragging this matter on for longer than it needs to be.
Well, those are baseless accusations. We've responded to their application for further particulars. They intend to bring more applications, so it's upon you guys to judge who's coming with delaying tactics in this matter, but those accusations are baseless. We've done everything according to book. Our application has the basis. We've indicated why this review application will be sent to the High Court, and the facts thereof are in the affidavits that we referred to in the court. So we will wait for the outcome of that review application. There's no delay tactic from the state.
There was also an argument about this a High Court application that certain documentation were not served to the accused beforehand that were supposed to be served there.
Well, if you are listening carefully, there were other accused who are not interested party. They are just people who just requested that they be furnished with these documents just for them to check if they don't have a bearing on the cases of their clients. But those who are directly linked to the application for the amendment of their bail condition, the correspondence was clear with their attorneys from the state. There were emails that we provided in court to prove that we've provided them on the day we filed the notice. We informed them via email. They acknowledged receipt of those emails. Therefore, with those interested parties who are not directly linked to the application, we have no basis not to provide them with that information as they requested to date, for them to ascertain if it has any bearing to their client's case.
You are not expecting delays come 13 February?
We're not expecting any delays. We are hoping that the judgment on the review would have come to us and for the matter to proceed. And we are hoping that by then there'll be an indication from the accused if they want to make further applications after we provided them with further particulars today.
Thank you very much.
Thank you very much.
2026.